I'd like you to talk about provisions that can be added in if they're doing something that will negatively impact me or my business, breaking the law in some way. I'll let you run with that. You know where I'm going.
Yeah. So, I mean, think about...
Not just a breach of the contract terms.
No, it's actually like they're doing something unlawful. Right? I mean,
or abusing my staff, or like there's a whole bunch of things that you can put in there that should be put in there. Well, so what are those?
True.
Yeah.
True. I mean, so it's going to definitely be context dependent. Mm-hmm. But if you hire someone to provide a service, say you're in advertising, you hire an advertising agency to create a bunch of stuff, and they are just going to send this out without you looking at it. There needs to be some sort of rep and warranty in the agreement that they're going to be complying with all advertising law. Like they're not going to go out there and say your dietary supplement cures cancer, or your dietary supplement does something that it otherwise, couldn't. It just doesn't comply with FDA law. If they're out there doing that, I mean, that's a breach. And if there's a provision in your termination provision or in your termination clause that says, material breach would include, violations of these reps and warranties, and they're defined. I mean, that's one way to get out of them.
Thank you. That's all really, really good. I want to go over the last one. And this last one is my favorite. It's my favorite because it's caused me the most stress over the past 5 years, like really. And so I want to discuss with you operating agreements. You and I have worked with, I want to say at least 6 different companies that either after they've launched their company are trying to get their operating agreement right, and it's been years of fighting, or they just ripped some operating agreement off the Secretary of State's website, and it's only that we're 50-50 partners and no real operating agreement. And so whether I'm a sole owner or I have partners, my firm opinion is that you need a proper operating agreement.
Truly.
And so I want to start with the sole owner and why I think, and then I'm going to let you rip on it. I think a sole owner, if they have a proper operating agreement that identifies the terms in which a partner can be added, claims against your business and partnerships that were not meant to be partnerships, but JVs, because those things get very clouded in our industry very often. It's not going to fully protect you, but it does hold some protections when you have it. So I'll let you talk about that, and then we'll move on to partners.
Well, yeah. So, I mean, just put in the JV context. Traditional JV should be 2 independent businesses going together and doing something.
But a JV could simply be my company sends affiliate traffic for your company. Mm-hmm. Now, I've brought you a ton of sales. You've given me a percentage of the sales. If I'm your sole or largest affiliate and I come to court and say, he's been paying me my percentage of the business, he told me I own the business, and here's like 4 Facebook posts where he called me his number 1 partner.
No, it gets muddy, right? Having an operating agreement
that sounds absurd.
No, but
that's actually a true story.
Yeah, it is. Unfortunately, if you have an operating agreement that says who the members are and a process for adding new members, you can't then have this JV all of a sudden morphing into... It's
not going to protect you completely, but it holds a lot of weight.
Exactly.
Okay. So now I want to move on to partnerships because I have so much to say there. You and I have talked about we've talked about this many times, if you can have a hard conversation when everything's great and we're going into business together, and whether it be an employee, a contractor, a service provider, or a business partner, if you can have a hard conversation now about how things get started, how we handle decisions, how we do things, how we wind down, what happens if you die, like if we can have those conversations now, because it'll blow it up, then you shouldn't be in business together.
Because it's going to blow up.
Right. Because that's a surefire sign. Whenever I hear that, I didn't want to have the conversation because it was too hard to have with him. Why the fuck did you go into business? What are you thinking? So I just let's walk through an operating agreement and what's important to have in there.
I mean, who are the members? Number 1, who owns it? Management responsibilities, who sharing of profits, expenses. Okay,
I want to go to sharing of profits because this is a question I get all the time. You own 50% of Emma Ryan Co. I own 50% of Emma Ryan Co. Do we have to take 50-50 distributions, or can we, or I've been told multiple times by CPAs, by the way, or can we decide in our operating agreement that I run the business, so therefore I get more of the percentage?
It's all dictated by the operating agreement.
Right.
I mean, the CPA response is, well, you guys are 50-50. I mean, they're just going to be looking at, well, you guys own 50-50.
Right.
They should actually be looking down at how all the distributions are being, the expenses and distributions are being shared. Expenses and profits.
So I want to just touch on that for a second, by the way, because I actually, my personal thought operationally is that when you own a business with someone 50-50, you take on the responsibility of having to do a capital call into the business 50-50. Payout should be 50-50. And if one person works more than the other, because one person does the day-to-day and one person doesn't, take a fair salary to adjust for that. That's my opinion on that, because I feel like it causes less problems, but you do what you want to do. But it can be done differently. Now, the next part, what you had said was, who is going to manage what?
Who's going to manage it? Like, is the key decisions.
The worst agreements say, we're going to manage it together. Everything's 50-50, by the way.
Well, at some point, you're going to reach a deadlock, right?
Right.
Well, I mean, before you even get there, what decisions require you guys both to agree? I mean, I guess if it's 50-50, then, which members can make certain decisions without consulting the other member? What is such a significant decision that, both members need to be consulted and basically have kind of like a vote? And then what happens when you guys can't reach an agreement? I mean, are there deadlock provisions? All these things can happen when all of a sudden it's like, how do you bring on a new partner? You want to bring on a new partner. I don't want to bring on a new partner, or I want to do this kind of business and you don't. Like when we reach a headlock, what are we going to do? Right.
And if you have 3 partners and it's 2 against 1, are we going to move forward, or does it all have to be, or does it need to be unanimous? You want to think through those things.